Okay. All right. I am pleased to call to order public meeting number 76 of the Massachusetts Gaming Commission. This one held at the Boston Convention Center on September 4th, 2013. At the outset of these meetings, we typically take an opportunity to recognize and welcome elected officials who are attending. I know that I believe Mayor DiMaria from Everett is here. Thank you. Nice to have you here. And a elected official at one time, former Governor Weld. I think you count. Welcome. Nice to have you here. And I hope I didn't miss any other.
Manager Joe Fernandez.
Town Manager Joe Fernandez isn't really an elected official. I think we'll hear from him. So, one other introductory matter, Commissioner Gail Cameron, who would ordinarily be here. Some of you know she had knee replacement surgery. She's doing fine, but it was just a week or 10 days ago. She wasn't able to attend us, so she will not be taking part in today's meeting, but she'll be back soon. Lastly, we may need to take a temporary adjournment while we get more space. There are apparently more people coming, so we're going to go along for a little while, and if it turns out we need more room and open the doors, we'll do that, but we will go ahead. Okay, first item is the approval of minutes. Commissioner McHugh.
The minutes, Mr. Chairman and colleagues, are in the book. There are a couple of typos which we'll correct in the ordinary course, and I think as Commissioner Zuniga and I talked a minute ago, the entry for 10:30 a.m. Needs a little fleshing out to put context there. The context of that discussion was that we had at our disposal at least three, and maybe a combination of ways of resolving policy questions that were raised by members of the public. And I think the context would be helpful there. Those ways were the ones that are listed here, but the context was that discussion of how we could resolve policy questions if they arose. So I propose that we'll add another sentence simply to make sure that that context is there. And otherwise, I move that the minutes in the form contained in the book, with the typos corrected, and with that addition, be approved.
Second?
Second.
All in favor?
Aye.
Aye. Opposed? The ayes have it unanimously. First item on our agenda is the Ombudsman report, which will include the two big public interest topics. First of all, before I turn that over to our Ombudsman and our General Counsel, a couple of people have come in asking where the sign-up sheet was for speaking. This is not going to be a public hearing where we will have an open mic and invite people to speak. There are several parties that have been specifically asked to come and make presentations. There are any number of opportunities for people to register their comments with us. As you know, we have a website, MGC Comments. In fact, some of the letters that came on that website are in our briefing book today. That's always reviewed. There will be public hearings about these proposals as they go forward further in the licensing process. And today, we are, for one topic, going to be just trying to establish some facts. And on the second topic, trying to just understand what the issues really are before us. It may turn out, after we see the facts clarified and after we understand exactly what the issues are, that we will reconsider offering an opportunity for other people to speak. But that is not our intention today, just so everybody has a heads up on that. With that, I will turn it over to Ombudsman John Ziemba and General Counsel Catherine Blue.
Thank you, Mr. Chairman, members of the Commission. As you're aware, we have a full plate today. The first matter up for consideration is the discussion of the questions related to whether the City of Boston should be determined to be a host community to the Win Mass LLC applicant. At the last Commission meeting, there was a discussion of the matter, and the Commission asked me to invite both parties to the Commission meeting to brief the Commission about the issues before us today. By way of further background, for quite some time, Commission staff have been communicating with both parties in an effort to determine how they can come to a better understanding of the issues. As reported to the commission at the last commission meeting, despite efforts by the parties and efforts by the commission staff, there still remain questions that remain unresolved. I'm pleased to report that both parties have accepted the commission's invitation. We have informed both parties that they should limit their presentations to approximately 1/2 an hour. They have been informed that the commission would like to hear from them about the nature of the issues, about outstanding questions, and about how the parties may be able to reach an understanding, and how the commission may play a role in helping the parties reach such an understanding. We have told both parties that the issue is how the definition of host community applies to the situation. However, we understand that the procedures and rights that impact host and surrounding communities are linked. Therefore, we understand that the conversation is not strictly limited to the definition of host community, although both parties have been asked to try to talk about that first and foremost. Given that context, I would like to turn to General Counsel Blue to outline the statutory construct of the host and surrounding communities definitions. After Counsel Blue's remarks, I will ask the City of Boston to brief the commission. The city's remarks will be followed by WinMass LLC's remarks. After the remarks, there'll be an opportunity for the commission to discuss what they have heard. Both parties understand that the commission will also raise questions during their presentations. With that, I turn to Counsel Blue.
Just before you start, I just want to just put my 2 cents worth in on sort of what I think we're trying to accomplish here. First and foremost, what we would like to do is facilitate a resolution of this issue between the parties. You know, that is the way it ought to get resolved. It ought to be done, and ought to be done quickly. If this process can facilitate that, that's by far the best way to go. Failing that, this process is to give us the underpinnings of the information that we will need to decide it on ourselves, which we will do quickly if necessary. But it's a 2-step process, and step 1 is to facilitate a resolution between the parties, which is far and away the preferred way for this to go.
Good morning. We thought it would be helpful to start with the definitions in the statute and the definitions that apply to this particular issue. So we have up on the screen, and commissioners, it's in your materials, the key definitions. The first one is host
Catherine,
community.
Can everybody hear in back? Okay.
The first definition is host community. This comes directly from the statute. A host community is defined as a municipality in which a gaming establishment is located or in which an applicant has proposed locating a gaming establishment. The sub-definition that plays into that is the definition of a gaming establishment. And a gaming establishment is the premises approved under a gaming license, which includes a gaming area and any other non-gaming structure related to the gaming area, and may include, but shall not be limited to, hotels, restaurants, or other amenities. The next definition that is important is the definition of surrounding communities. That definition reads, municipalities in proximity to a host community, which the commission determines experience or are likely to experience impacts from the development or operation of a gaming establishment, including municipalities from which the transportation infrastructure provides ready access to an existing or proposed gaming establishment. There are some key differences between the host community and the surrounding community's definition. A host community has the ability to hold a referendum in the community to determine whether the community will accept that gaming establishment. And they enter into a host community agreement, which is an agreement that covers a broad number of topics that include mitigation in the community, but can also include other issues. Host community regulations are found in 205 CMR 123. A surrounding community is slightly different. The surrounding communities do not vote on the application for a casino. Surrounding communities are determined in a number of ways, the key ways which are they're designated by the applicant and by the surrounding community or by the commission. And you can see the process for that in the regulations at 205 CMR 125. Surrounding communities enter into surrounding community agreements that address the impacts or potential impacts from the gaming establishment. And if the surrounding community does not enter into an agreement with an applicant prior to the filing of the RFA2 application, there is a process by which the community and the applicant can go through binding arbitration. So they have different obligations and slightly different processes. The other definition that we think is important to consider here is the definition or the language found in Chapter 23K, Section 1513, and this talks about the election. Section 1513, it pertains only to the question of how elections are held in host communities. And if you look at the bottom of that, what the language provides is that for the purposes of this clause, which is for the purposes of the election only, unless the city opts out of this provision by a vote of the local governing body, if the gaming establishment is proposed to be located in a city with a population of at least 125,000, by the most recently enumerated federal census, the host community shall mean the ward in which the gaming establishment is to be located. We just want to emphasize that this definition applies to the election language and does not supersede the host community definition that is found earlier in the statute.
Right, and this is relevant because there's been commentary in the media that has asked the question, is Charlestown a host community or not? And that's would be a misunderstanding. The question is whether Boston is a host community or not. If it were, where the election would be held would be in the appropriate ward. But that's why we want to clarify that point. But there's been discussion in the media that seems to misunderstand what a host community might be.
So those are the key definitions that impact the discussion we're going to have today, and we're hoping that the applicants will discuss this, as will the other presenters.
Thank you, Council Blue. With that, I'd like to invite Elizabeth Della Russo. She's the Executive Director of the Boston Host Community Advisory Committee, and Abim Thomas, outside counsel for the City of Boston, to give their remarks.
Thank you, Ombudsman Ziamba. Elizabeth Della Russo for the City of Boston, and I'm joined by Counsel Larry Kaplan and Abim Thomas from Goodwin Proctor. I want to thank the Commission for inviting us here today, Chairman Crosby, members of the Commission, and the Commission's staff. We are hopeful for a productive and open conversation. I also want to acknowledge our elected officials as well, Mayor Carlo De Maria, former Governor Bill Weld, representatives and members from the Charlestown neighborhood, and other Boston residents who are here today. We are here for three important reasons, the first of which is to help clear up confusion on the part of the Charlestown neighborhood, which the city represents. We also want to understand the effects of this proposed development on, in particular, that Charlestown neighborhood, which we feel will have a disparate impact. We also are here to further our request for information, which has kind of been a long, ongoing process. So first, to begin with, on behalf of the Charlestown residents and businesses, there is, Chairman Crosby mentioned, a petition that has circulated amongst Charlestown. At this point, nearly 500 residents have signed this petition. There is, I think, a point of confusion in the petition regarding Charlestown being its own host. But the spirit of that petition is that we are hearing clearly from many residents that they are confused about the status. Some are not confused. Some are adamant about the status of Boston. On behalf of Boston, I would say that the city itself is confused about the status here. And part of that confusion is because we're looking for some additional information, which we have not yet obtained. The confusion, I think, comes from the developer itself. That there have been images that have been public, which have led to the city and the residents questioning where this development lies, and whether or not it crosses municipal boundaries. And we have some images that we would like to show, which illustrate this confusion, what appears to be a shifting landscape of boundaries. I'm sure that we're going to be shown more maps today, and I'm hopeful that we will be. Although long delayed in showing them to the public, to Boston and the residents, we welcome any clarity that maps or images or explanations that this will bring to the public. I also want to talk about the umbrella issue over things like images and maps, which is the impacts on Charlestown and on Boston, which is really where Boston has spearheaded this entire conversation. What we're looking for and what we're trying to understand is the impacts. And we believe that that comes directly out of the act itself, the Gaming Act. So really what we would like to see is some information so that we can review it as we've done with other applicants, and we can let our neighborhood of Charlestown know that we are actively seeking to understand the impacts of which we feel may be significant.
Well, whether Boston is a host community or a surrounding community, that is going to be part of the process
Yes.
that has to be undertaken for the application. So in that sense, that's a given. Some form of review and an opportunity to focus on mitigating efforts is going to be part of whatever package is ultimately presented to the commission.
Thank you, Commissioner. We agree
Okay.
that this is kind of the umbrella issue, the status of host versus surrounding.
Well, I understand that,
Okay.
but it's not an all or nothing proposition. In other words,
No.
it's not, if you're a host community, you get a chance to talk about mitigating impacts. If you're a surrounding community, you don't. You get a
Correct.
chance to talk about mitigating impacts in both cases.
Correct.
So, and everybody ought to understand that.
Thank you.
And just while you're talking, you said that the second umbrella issue was this impacts, and you said that comes right out of the gaming legislation itself. Where are you referring to that comes out of the legislation itself?
I think that the legislation speaks to, regardless of status of host or surrounding community, that if there are impacts, those should be mitigated. So, I think the city of Boston views this as we're seeking information to understand those impacts. That's really the largest issue before the city of Boston. We are confused about the status. And
Okay. But understanding the impacts doesn't speak to the issue of host community versus surrounding community, which I guess was Commissioner McHugh's point. Understanding the impacts is very important, and it will be something that has to happen whether or not Boston is a host community.
correct.
So I don't want to
Boston
conflate
is-
these two. I don't want to conflate these two issues. Understanding the impacts is a relevant topic to either issue, to either designation, and we're here to figure out what's the designation, not what are the impacts.
And let me kind of clarify the rub of this, which is Boston has sent multiple letters seeking information to understand impacts. And information what we've received in response is that once Boston says it is a surrounding community, information will be shared with us. In part, we're looking for information that clarifies our status. So if a developer will only share information upon our saying we are a surrounding community, when we are confused on that point, I think that is contrary to the spirit of the gaming law. And I think that is where we are not being able to obtain information. And that's why I say the umbrella issue is the impacts.
But there are two ways to solve that, at least, are there not? One is to decide whether Boston is a surrounding community or a host community, and then the developers pledge to take action in response to that. We'll have a platform to do it. And the second way is to have a voluntary exchange of information, which, as Chairman Crosby said earlier, would be the preferred route. But in either event, that issue ought to be resolved promptly, because it's going to need, the impact issue is going to need some careful consideration before the applications are filed. Right?
I think we're
Correct.
I think we're on the same page on this, but
Yeah.
understanding the impacts will not necessarily clarify the issue
Right.
of whether you are a
Right.
host or a surrounding community.
Right.
If there has been a failure to give you information to make a reasoned determination whether you're a host community or not, that's something we're here to try to facilitate. That is definitely on the table. But I think we know, what the distinctions are here, so.
And I would hope, Commissioner, that if there's a failure to give information so Boston can understand impacts, that is something that the commission would hear us on. I think that time is of the essence. So, for the city of Boston, for our residents, we really do need to have some information so that we can do some analysis. In other applicants within the city of Boston, we did years of analysis. So I understand that that's not possible in this instance. The site was selected quite a bit after Suffolk Downs has been an ongoing site for 78 years, so there's some distinctions there. But Boston is ready and able to have experts do some analysis so we can understand impacts and reach the appropriate agreement. I think I would like to turn it over to Abim Thomas to explain why Boston has been confused on the issue.
And again, thank you, Chairman Crosby. Thank you, commissioners, for having us here today. We really appreciate this opportunity, and we'll really rely on the commission to help get to the bottom of this issue and to really help clarify this. Liz hinted just briefly at what the communications have been to date with the developer here, and that they unfortunately have not been very forthcoming with information. She discussed how, at times, when the city has sought information, they have stated that they would provide it, but only on the condition that the city of Boston state affirmatively that it is only a surrounding community and not a host community. And in our opinion, that's just not the way to have an effective conversation about this topic. So I will, allow, just talk briefly about, I'll quote just briefly really from letters that WIN has provided to the city. For example, in their letters, the language states, prior to scheduling a meeting, we want to clarify that Boston is no longer seeking host community status. Following your acknowledgement that Boston is not a host community, we would be prepared to discuss with you Boston's status as a surrounding community. And again, that's just even to have a meeting. With respect to gaining information, WIN has refused to share information except on the condition that Boston declare that it is not a host community. WIN has stated in its letters to the city, we will share impact studies and traffic reports with you only in the context of surrounding community negotiations. So I think WIN's really putting the cart before the horse here in calling for the city to declare that it is not a host community for this proposed project. And it would be irresponsible for Boston to determine that it is not a host community without additional information. Liz didn't mention this, but Boston actually went so far as to submit a public records request to the city of Everett in order to get information because the city was having such a hard time getting at this information and paid close to $850 to obtain that information. So we couldn't be happier to be here today to really rely on the commission to gain us the information we seek. We hope it will be a much cheaper approach to getting this information. So I'll just ask Larry Kaplan, who's also here on the city's behalf, just to talk through some of the information that the city has sought to date.
Yeah, thank you, Mr. Chairman, members of the commission. Larry Kaplan from Goodwin Proctor. Very briefly, we do want to be on board as to whether we are host or surrounding community. And one of the things we're looking for is a current site plan of the project that will clearly define where the gaming establishment is and all of the amenities. I think as Abim will show later, there have been several inconsistent images that have been presented by the WIN representatives, several of which show the project as being in the city of Boston, which is one of the reasons that there's been confusion as to whether the city is a host community or not. And these are their own images, they're not images that we have produced. So
Okay, so this is a specific request that the city has made to WIN for a site plan showing the establishment and the amenities. That's been part of a letter that was sent, was it?
Correct. Yes.
Yes.
Okay.
We're also
And
interested.
you've not received that site plan showing the site plan and the amenities? You've not received that?
No, we have not.
That's right.
Okay.
We would like to, we're interested in the municipal harbor plan that's underway. We'd like to see the extent of that. We'd like to see where exactly that plan is, where, any boardwalks and harbor walks are going to be, and whether they're just going to be located in Everett or whether they're going to be located in the city of Boston.
Well, wouldn't that be part of the site plan? I don't want to cross-examine you, but
No,
I am
I
trying to figure
understand,
out.
no, I appreciate that. I think it is, but I'm just trying to be a little more specific
Okay.
on some of the things we're looking for, Commissioner. And I know we're not here to talk necessarily about impacts, because impacts, we agree on whether you're a host or surrounding. But since a great deal of, our representation of the Charlestown residents is going to center on traffic impacts, and since so much of the traffic is going to come over Boston roadways, we would like to see current traffic studies, and because we don't think they're taking into consideration some of the traffic downsizing, if I could say, or road narrowing that the city is going to be undertaking. And that's very important, because we want to be prepared to at least address these impacts, whether or not we are a host community or surrounding community. I know we're not here to talk about impacts, but that's very important to the Charlestown residents. So I think that's kind of it in a nutshell as to what we'd like. As Liz has mentioned, it's been difficult to get, and we're hoping that the commission can assist us on that.
So if I understand you, what you're looking for is a site plan.
We would like to, yes.
Putting
I'm
to one
looking-
side the traffic, which we all agree is important, but that's important whether you're a host community or surrounding community. What you're looking for is a site plan.
That would show all
precisely-
buildings,
Precisely defines,
all buildings
Right.
and all amenities,
Right,
Commissioner,
right.
correct.
Okay.
That's correct.
and including the boardwalk, the entire,
Yes.
the whole shooting match,
The whole shooting match.
in precise terms, right?
Right.
Okay.
In very precise terms, and I'll just cite to Section 9 of Chapter 23K, and, it speaks to the location of the proposed gaming establishment and what the applicant has to provide to the commission in its application. And we know the application isn't due until the end of the year, but we assume that this is information that the applicant already has. In the statute, it says, in providing the location of the gaming establishment, the applicant is required to include, quote, the address, maps, book and page numbers from the appropriate registry of deeds, assessed value of the land at the time of application, and ownership interests over the past 20 years, including all interests, options, agreements and property, and demographic, geographic, and environmental information, and any other information requested by the commission. So again, it's early. I understand they have not submitted their final application yet, but as they're preparing that final application and clearly putting that information together, that would also be information that would be helpful for us to have.
Well, but it would be helpful perhaps in some ways, but the site plan, it seems to me, for determining whether they're a host community or not is the key, is it not? Can we agree on that?
Yes.
Okay.
And so I'll just, go back. We're just going to show some of the graphics just to explain some of the confusion that there's been to date with respect to the project site. And I'll start just by showing a completely different site. So this is the Suffolk Downs proposal. And I show it just as an example to clear up any additional confusion about whether or not there can even be two host communities. This is the Suffolk Downs proposal, and the line you see that bisects this proposal shows the border between Boston and Revere. So this is an example of a proposal that's located into cities. You'll see here from this image that Suffolk Down retained a portion of the track and some of its parking and off-site facilities in Revere. And Suffolk Downs has treated Revere as a host community for that project and negotiated a host community agreement with Revere, even though the planned casino itself is located on the Boston city side of the line.
I would say for the record that I think that was an appropriate decision.
The next slide I want to show here is an aerial view of the Monsanto chemical site. The Monsanto chemical site is relevant because this is how the site is commonly referred to. You'll see the portion outlined in red here. That's the portion of this aerial view here that's actually located in Boston. And outlined in blue there you'll see is actually the portion that's on land within the city of Boston.
Well, I don't understand that now. Could you help me with that? The part that's in the previous slide now, the part that's in red within the blue circle is what?
Boston.
All right, and what is the rest of the blue circle that's outside?
Oh, it's just to call attention to. It's just to call attention to the red sliver.
Okay, so that's just an attention getter.
Just an attention getter.
Okay.
Yeah.
And to the left of the red line that's in blue is Everett, and to the right of the red line, of the other red line, is in Boston.
That's correct.
Okay. And these straight lines, the red line that goes down and then dog legs to the left and down again, that defines the Monsanto site, so-called?
It's also part of the Monsanto site, but that too is in Boston. So what extends into the Mystic River there is also Boston.
Okay, but
What is to the right of?
Still Boston. So if I have a pointer here, which I'll try and use. All of let's see if I can get this. This is the site right here, and we'll get into more detail about the site. But this is the site here. One could argue this is the full site. We've seen different images. We'll see more images about the complete site. But this is just an aerial view to help understand the site. To your question, all of this located to the left here, this is all Everett. Everything located to the right here, this is Boston, including everything in red. But the red outline defines the parcel of the Monsanto chemical site.
What is southeast of the red outline?
Southeast,
Everything southeast.
more of Boston. You got your pointer too?
yeah, right
We
there.
won't
That
compete
area,
with,
right?
with our pointers.
And the street, Route 99.
Right.
All of that.
Boston. Mhm.
In the extreme lower right-hand corner, that is not Boston. Route 99, the roadway you see there, the property to the right, immediately to the right of the red outline, that is Boston.
But once you cross 99 into the Scythe Energy plant, the power plant, that's Everett. Is that correct? 'Cause I'm familiar with the power
With the
plant.
exception of that red sliver.
Use the pointer, because I can't,
Oh,
I'm not
sorry.
sure what you're talking about.
So this right here, and actually, Commissioner Zuniga, when you cross 99 to enter into the site, are you referring to any particular location?
Southeast, yeah. Let me see. There's a power plant.
Watch Bruce's
Here.
eyes.
All of these
Mhm.
is Everett. Is
It
that
is Everett.
correct?
Correct.
Okay, and this is Route 99.
Boston.
This is Boston.
Yes.
And I'll, sorry to compete with pointers as well. So here also more of Boston.
So there's a little skinny piece of Boston that comes up
Correct.
with Everett on both sides.
Correct. Yes.
All right.
Yes. And this is, part of the confusion here.
Yeah.
Right.
Route 99 does become Everett. It becomes under Everett jurisdiction just around past the red
Right around
marker.
here.
Yeah.
So Route 90, say again, Abim?
Do you like me to stand up?
Yeah.
Okay. I'll do my best here. Here's Route 99. This is Boston jurisdiction. This is Boston. The red outline is Boston. Route 99 is Boston. Below 99 is not Boston, that is Everett. And then up around here, Route 99 becomes Everett jurisdiction, and past the red, it is Everett jurisdiction.
past the red on the right is Everett also. Past the red on the right.
Past and up.
Past
The
and up.
line here is Boston.
Yeah, but at the top, right, from the top up on the right is Everett. I'd like to hear the history of that little piece, but James Michael Curley had a hand in that one.
And just, I mean, this is really just the first image, but I hope this helps to clarify why there's been so much confusion about this site. And again, this is just to provide the backdrop of the Monsanto chemical site, which is how this site is often, referred to.
Excuse me, is the piece outlined in red one parcel or several parcels?
The piece outlined in red is a parcel that pays taxes within the city of Boston. It is it is owned by a company named, it's a matter of public record, FBT Everett Realty. That company, we believe, owns the Monsanto site. So it also owns land in Everett, the remainder of that big parcel there. And it is our understanding, and some of what we're seeking clarity on, that FBT Everett Realty has a lease agreement with the wind development, and we're trying to understand, does that lease include this red parcel? In which case, the lease itself would include Boston land.
So this next slide is an image that's been provided by the mayor of Everett's office, again, showing this same parcel outlined in blue. And again, the circle is just very broadly drawn to show the portion of the site that's located within the city of Boston. This image was taken, and made available back in March, but my understanding is that it even predates March 27th, but this is an image that was provided to describe the site yet again. This image is an image that's provided in the Win Everett brochure that shows all of the hotel and casino development along with its amenities. And as Larry mentioned, this harbor walk that it also shows. My understanding is that the portion, in the right-hand corner there, really is representing that piece of land we showed earlier that's located within the city of Boston. You see the harbor walk that goes along the edge of the river here. It comes along, and you see a lot of these amenities, the same on the left-hand side of the bank here, with the rocks and the landscaping. It's the same along the right-hand side of the bank here. All of this within the city of Boston.
Just, go ahead.
Although it should be noted that this is, a rendering that can be put together in many ways and should not be construed as a site plan by any.
Absolutely, and just to be clear, all of the images we're showing now are just images to explain to the commissioners and to the public why there's been so much confusion around this site and why the city has been seeking more information to understand exactly what WIN's plans are for this site. This image is taken from the Win Everett Host Community Agreement. This is an attachment to the Host Community Agreement that's referred to as Exhibit A and referred to as the Project Site Plan. I'll also note that in the Win Everett Host Community Agreement, this is also referred to again as the Monsanto chemical site. Again, this image is very grainy and probably hard to make out, and you see the border between Everett and the city of Boston. You see that border drawn, and you see that, again, there's that sliver, there's that portion that's located in the city of Boston. But again, to be clear, this entire image was the image that was provided to the voters of Everett when the host community agreement was entered into as the project site for the Win proposed development. Here's another image. This is an image that was provided in a Win Everett community meeting presentation. And again, this presentation was provided on May 21st. Going back to the earlier slide, as I mentioned, this is the Win Community Host Agreement. This was entered into on April 19th. So here you have the Win proposed site from a presentation, 1 month, virtually 1 month after the host community agreement was entered into. Again, we see the outline of the site, and again, we see this portion right here of the site that's located within the city of Boston. Part of that same presentation included the same rendering we saw earlier with the city of Boston off there in the lower right-hand corner. And the same presentation also included this image, which is a current view of the Monsanto site today, again, with that lower right portion, the water as well as the bank located in the city of Boston. Here's just another rendering that was provided, this one on June 13th. This is a 3D model of the wind proposal, again, with that right bank all located within the city of Boston. So again, these are just images.
I just want to clarify one thing. Could you, let's see, is this, no, which, back one slide, I guess. Can I have the pointer?
Yeah, sorry.
So the property line runs.
Yeah, and again, I didn't draw the property line here. We can provide you with the exact property line, but I'll use my pointer really quickly to try and draw it as best I can. The property line would come, and my pointer may no longer be working. I apologize. But it juts out into the bank, and maybe it's.
Well, it's basically, is it basically parallel with the side of the water?
No, it's actually probably easiest to show. I mean, it's hard to show on this slide. It's probably easiest to get the line really from
I see,
here.
from the original.
Yeah, and you'll see how
Yeah,
it juts
okay.
out. I mean, there's really a very, very narrow opening that provides entry really into, into that area if you were to carve out the Boston portion.
Okay.
Does that answer your question? Yeah. Okay. All right. So, I share these images really only to provide context for why we're even here today and why the city of Boston has sought more information from WIN to try to understand more about their development. We're really here today before the commission to rely on the commission's mission, which is really to a fair, transparent, and participatory process, as well as a speedy process. So we're really asking for the commission's help in obtaining the information that we've been seeking, because the commission is the body with the authority to get this information. Under its regulations, the commission has the authority to request this information from WIN. I'll cite to 205 CMR 112.01, subsection 1, which says the commission may request additional information and documents from the applicant throughout the application review process. And WIN would be required to comply with this information under the same regulation, which states that, quote, all applicants shall comply with all requests of the commission for information and documents. We know the commission is eager to move forward with this matter, as is Boston, and that's why we hope that the commission will not just request this information, but also expedite the process for getting it by relying on its regulations, which impose a 10-day deadline for providing this information. Under 205 CMR 112.02 sub 1, it says, quote, applicants shall respond within 10 days or within the time specified in an information request by the commission under the same site I just cited above. The commission has not just the authority to request this information, but also the ability to, eliminate an applicant from the process if the applicant fails to comply with these information requests. So pursuant to 205 CMR 112.02 subsection 3, it says, quote, if the commission determines that an applicant has knowingly failed to provide information or documents requested by the commission may, with respect to such person, find the person ineligible to hold the license. And finally, in our opinion, there's really no better way for us to acquire this information than really through the commission, because we can be assured that the information that will be provided will be accurate and truthful information, or again, the applicant will risk its eligibility for a license under 205 CMR 112.03, subsection 3, it says, quote, no applicant shall knowingly provide materially false or misleading information to the commission. If the commission determines that an applicant has knowingly provided materially false or misleading information to the commission shall find that person ineligible to hold a license. So therefore, we're really grateful to the commission for offering to help expedite this process, and we ask the commission for their help in obtaining this information that we've been seeking. With that, I'd like to turn it back to Liz.
Thank you, Beam. I hope that in going through these images and having this open discussion, that all parties can leave here with some clarity. In particular, any residents that are here from Boston, from Charlestown. My hope is you understand why Boston has posed the question. And I think it would be irresponsible of Boston not to have asked the question of what's going on in this parcel and what's going on at this site, and asked for information. And as I said, to understand impacts. That is incredibly important to Boston, knowing the limited amount of time, but also to understand status. I very much look forward to what the developer will share with us today, and we're hopeful for an open discussion here. Thank you.
Can I ask a question? Maybe, Catherine, you could help me just put in context some of the regulations that Ms. Thomas was referring to are specifically, the 10-day limit are specifically for a time after the application has been submitted. Is that not correct?
That's correct.
Thank you. Your point is well taken, and
But
we're
actually,
here to do
but
that.
I'll refer, Catherine, to the section of the provision that says that the commission can ask for information at any time
do.
throughout the
We do.
application process, and that includes both phase 1 and phase 2.
Understood.
Anybody else? I think just, to reinforce the point that Commissioner McHugh and I were making before, this is a very legitimate conversation. This is genuinely confusing, and this is the sine qua non of the topic. When you insist on bringing in the impacts issue, you muddy the water, and I'm now beginning to see what's going on here, and people who aren't very aligned to talking routinely with one another, starting to stand on these points of principle that really are getting in the way. And I perfectly appreciate that this is confusing, and I hope we will get this clarified. But to continue to insist on the impacts conversation is a distraction, and I can understand how, when there are tensions, it makes communications difficult. Okay.
Thank you.
Thank you.
Thank you, Mr. Chairman. So now we invite members from the WIN development team to come brief the commission. I invite Kim Sinatra. She's the Senior Vice President and General Counsel of WIN Resorts, and she will introduce the rest of the WIN team.
Good morning, Chairman Crosby, members of the Commission. My name is Kim Sinatra, and I'm the General Counsel at WIN Resorts. I'm very happy to be here today. This is our first sort of formal/informal appearance before the Commission, and we hope that we have many fruitful discussions as we move forward. The issue before us is frankly not one that I thought that I would be here about. For us, we're not confused at all, but we're hoping that we can dispel any confusion that other parties may have with respect to this issue. I appreciate the Commission's knowledge and study, as well as staff, with respect to the issues and the definitions. We approach this project, as we do all projects, with a great degree of intention and deliberation. And so we're hoping that we, without any big red circles, can sort out the cut and dry definitions, as well as the configuration of the real estate upon which we propose to invest over $1 billion in the Commonwealth of Massachusetts. So I am accompanied by my magnificent team from Mintz-Levin today, as well as Mayor DiMaria. First, we have a person who probably doesn't need much introduction here, which is Mr. Weld. He's accompanied by his partner at Mintz-Levin, Pierre Biagetti, and Dan Gaquin, who is a real estate partner at Mintz-Levin. And I think after an introduction by Mr. Weld, will provide you with some maps and a site plan that hopefully dispel the confusion that we have reigning today. With that, I'm going to turn it over to the team.
Thank you very much, Mr. Chairman and Commissioners. My name is William Weld. I'm a member of the law firm Mintz-Levin and the Mass Bar. My bar registration number is 522280. Very happy to be here. Happy to have heard the chairman indicate that part of the purpose here is to assist the parties in reaching an understanding. That's what I do, as they say, and I'm hopeful that we can see a path today whereby the parties can advance in understanding. The applicant, WinMass LLC, has proposed, as you know, a $1.2 billion development located in the city of Everett. It's registered land. It's on the Mystic River. You can look it up in the Middlesex County Registry of the Land Court. It is Parcel B on Land Court Plan 18691A, filed with the Middlesex South Registry District of the Land Court in Plan Book 485, page 177. And the parcel does not contain any land or structure in Boston or in Suffolk County. There was a referendum on the Wynn proposal, which received an 86% affirmative vote on June 22nd, 2013. There's no other city is going to be proposed as a host for the Wynn proposal. I can assure you of that, and all of the land is located within Everett, as appears from the official filings. It follows under
Is
the
all of the land, Mr. Weld, part of that registered land that you just referred to?
The land that I'm referring to is the parcel that I referred to in the Middlesex South Registry. That's going to be the parcel that will be the subject of the application filed on December 31. And it doesn't contain anything in Boston or Suffolk County.
All right, so that all of the gaming establishment,
Right.
It's your position, is on that piece of registered?
That's right. That's right.
Just to clarify, there's a small piece of recorded land in the middle of that parcel, but primarily the parcel is a registered parcel.
That's why we have real estate lawyers
Right.
to clean up after us.
All right.
So under the definition of host community, which is, you have before you anyway, but it's up on that chart, it's the municipality in which a gaming establishment is located. Well, there's no establishment there yet. So the operative part is in which an applicant has proposed locating a gaming establishment. So that's going to be Everett. It is true that the city of Boston is in close proximity to the site, in fact, and a butter. And it's also true that there are going to be impacts, particularly on Charlestown, which is part of the city of Boston. And there are going to be traffic impacts. And I've walked the site and I've driven around the site, and there's a good bit of work that could be done in renovations to Sullivan Square, maybe the Alfred Street Bridge. And that's going to be in the city of Boston. So I think the implication of that is that Boston is likely, or very likely, a surrounding community within the meaning of the statutory definition, which again, just very briefly, surrounding communities are municipalities in proximity to a host community, which the Commission finds are likely to experience impacts from the development or operation of the gaming establishment, including, and this applies to Boston, including municipalities from which the transportation infrastructure provides ready access to an existing or proposed gaming establishment. That's a perfect definition of the city of Boston as it applies to the Everett proposed project. And as Council Blue indicated, surrounding communities don't vote on these projects. And that was raised when the legislature was considering this statute, and they very expressly made a determination not to give surrounding communities a voice or a vote as to whether the thing goes forward. I remember Senator Stephen Brewer said, no, we can't have that. That would be a poison pill. Nothing would ever get built. So the legislature defined surrounding community and gave it the rights and the rights that it has very expressly. So there's a big distinction, obviously, between being a host community and a surrounding community. Mr. Chairman, members, the feelings that you referred to, Mr. Chairman, there is nothing personal here. We love Tom Menino. We love the city of Boston. We want the city of Boston, which is right there, right next door, to receive fair compensation for any and all impacts on the city of Boston, including, I would think, most particularly on the Charlestown part of Boston, including traffic. And we're not here to ask for any variance or special treatment or favor. We just want to make sure that the commission and the selection process follows the law in a matter where the law is pretty clear. In fact, it's completely clear. So that's all we're really looking at. Finally, and I'll yield to my betters here, but a word as to the practical impact of a decision here on this host community point. If anybody, the commission or anyone else, went through a process and decided that although the site and the registered land and the recorded land is 100% within the city of Everett, nonetheless, the proposal is, quote, located, close quote, within the city of Boston because Boston is just so close, it might as well be there, might as well be considered a host. The practical impact of that would be to effectively eliminate one of the major competitors for the Eastern Mass license, because that would give Boston the vote, and that's the power. It's really up or down power, because the city would have the power to delay engaging on a host community agreement, so it effectively could kill the project by not exercising and not having a referendum. And there would be an unlawful granting of that power to the city of Boston, but nonetheless, it would mean that there wouldn't be much point in the wind companies continuing to spend money in pursuit of this goal here. The second thing I would suggest, this is more political than something I can prove, but you might well end up with no Eastern Mass casino. And the reason I say that is that although Wynn has had the referendum, the Suffolk Downs proposal still faces two referendums. And I'm sure that, you know, the proposal put forward by my good friend Joe O'Donnell, who's the principal behind Suffolk Downs, and he is my good friend, has many, many meritorious features. But we are into election season. There's going to be an election for a new mayor on November 5th, new mayor of the city of Boston. I read in the papers today that the Revere City Council just approved their agreement last night, so the 60 to 90 day period starts running today, which means the earliest that Revere could have its referendum would be November 4th, which is the day before the vote for mayor in the city of Boston. And, you know, the Suffolk Downs proposal, in fairness, has become at least a minor issue in the Boston mayoral campaign already and could become a major issue, and if it's being decided on the same day, all I'm saying is no outcomes are certain in a hotly contested election season.
That may increase and probably focus on the consequences of the decision, but as one commissioner, I think it's it's terribly important to me to make it clear that the decision that the commission is making today is a decision based on the application of law to fact.
Right.
That's what we're doing, and that's all we're doing. Right. We're trying to look at the statute, we're trying to figure out what the facts are, and apply the law to the fact, and the consequences are what the consequences are. And as one commissioner, I want that clearly understood, notwithstanding the consequences that may flow from that exercise.
And it's been the suggestion that there was something other than what Commissioner McHugh said that's been troubling to us and why we're, part of the reason we're here today.
Yeah, no, that's right. And I think Council Blue laid it out pretty crisply, the applicable law. So, you know, if there was no Eastern Mass Casino, and I realize this is not at the heart of the matter, but that obviously would have some fiscal impact, since my understanding is that money's been pretty well spent already.
There is another proposal, by the way, apparently on the
There's a
table.
third proposal.
There is a third proposal, by the way, in Eastern Mass.
Yes, well, that, for another day, But that's really all I've got, Mr. Chairman. I will yield to Mr. Biagetti for perhaps a slight further mention on the law, and then Dan Gakewen, our real estate man here, has the site plan and can answer technical real estate questions.
Thank you, Mr. Weld. Peter Biagetti, and as my colleagues have said, I was here to help to the extent the commission needs it on questions about, as Commissioner McHugh just said, the application of law to the facts here. But I think in the spirit, Commissioner Crosby, that you mentioned at the outset of trying to facilitate resolution here, that what I heard in the city's presentation, at least on the law, was quite heartening. We have consensus, I think, on the two key questions or applications of law here. Council Blue, of course, is exactly right that there are key differences between the definition of host community and the definition of surrounding community, which in turn implicate differences in the roles that the legislature intended that this commission would play with regard to each. And let me explain on each of those. Council for the City mentioned we're not here to talk about impacts. We completely agree. Impacts are relevant per the definition of surrounding communities only to a determination, the statute's words, by the commission of whether or not such impacts or likely impacts are enough to constitute surrounding community status. And the commission quite properly has regulations which talk about what those sorts of impacts are to be on the environment, on traffic, on businesses. But we're not here to talk about those impacts today because this is not a determination today of that surrounding community status. Those impacts are relevant only to that issue, and Wynn Resorts stands ready to answer any question the commission has or the city has with regard to those impacts which are relevant to that determination of surrounding community status and only surrounding community status. But that brings us to the second point of what I heard as consensus. Commissioner McHugh, when you asked whether host community status would be determined only by the site plan and its boundaries, Council for the City quite properly agreed. Nowhere in the definition of host community is there any mention of impacts, and for good reason. The legislature did not intend for this commission to have to weigh impacts in its decision or in its approval of a license from an applicant with regard to the premises that will constitute the location then of the host community. The question of host community status is driven by, per the definition of gaming establishment, the premises in the application. That's a question of pure geography. It begins and ends with, Commissioner McHugh, what you rightly called the boundaries of the site plan. And that's what we're here to discuss today. And I'm going to yield to my partner, Mr. Gakewen, because he's going to show you the documented site plan, not a brochure, not a photo, which begins and ends the inquiry into host community status.
Thank you, Peter. Good morning, Mr. Commissioner and members of the commission. My name is Dan Gakewen. I too am a partner at Mintz Levin, and I'm here on behalf of Wynn Resorts and the project applicant, Wynn Mass LLC. I'm a real estate lawyer, and I've been working on this project really since Wynn has been involved, and I'm very familiar with the project site. So what I'd like to do is walk you through some land surveys and project plans to provide you with the facts relevant to the question of host community status. that is specifically the location of Wynn's proposed gaming establishment. The plan to the right here is a land survey that shows the principal project site. It is an approximately 30-acre parcel located off Horizon Way in Everett. It is controlled by the proposed applicant under an option agreement. The parcel consists of approximately 22 acres of upland and 8 acres of submerged land or land underwater. As you can see, the southerly boundary, and we've outlined this in blue, is also the Everett-Boston property boundary, as well as the boundary of Suffolk and Middlesex County.
Excuse me, I'm not getting this. Which are you, is it that?
I'm referring to the plan to my right.
Where's the site? I don't see the site.
It should be,
It's the second slide.
It's this one, yeah, but this doesn't look at all like the site to me. Where is 99, for example? Where's the water? Oh, so it's this way?
it should be the second plan in your package. The first plan, the first sheet is the definitions.
Yeah, so Alfred Street is 99? Okay.
Alfred Street is Route 99. Horizon Way comes off of Alfred Street and leads to the project site,
Right.
the gaming establishment premises.
Right, okay, so this is analogous to this, yeah, okay. Okay, so,
Chairman Crosby,
Can I help with
would it be
orientation?
acceptable if Dan stood up there and
sure,
could use his finger?
please, not only acceptable,
I think that
it would be
helpful.
appreciated.
So this is the project site development.
Yeah, okay.
Want the audience to see it. This is Alfred Street coming in from Boston to Everett.
Okay,
This is the line, the Boston Everett line, and also Middlesex Suffolk County. Horizon Way, which is the current access to the site.
yeah, okay,
Again, this is the parcel.
yeah, it's, usually north is at the top, and that threw me for starters, okay.
Put in the context of the Gaming Act definitions, this is the premises where Wynn proposes to establish the gaming establishment. That is the gaming area and the non-gaming structures related to the gaming area.
Now,
This is where they will be located.
Okay, but the line which is red and blue
Yes.
It's the border of
is the
Boston.
border of Boston and Everett.
Correct.
But the parcel of land, so what, you're not talking, the Monsanto, this is not the Monsanto plan.
It is a part of the
It's the
Monsanto
part of
plan. and
Monsanto,
I'm gonna
but
get
it's
to
only
the
your
Boston, I'm gonna
but
get to the Boston parcel.
It's only the portion that you're using supposedly for the facility,
Correct.
for the gaming establishment.
That's
Okay,
correct.
okay. So this is not the Monsanto parcel, this is the parcel, piece of that which is being used for the facility. Okay,
That is correct.
all right, gotcha.
The second plan to the left is a roof plan or site plan, which shows the structures comprising the gaming establishment premises and the roadway access as proposed by Wynn. And again, the boundary of Everett and Boston is outlined in red, and as you can see, the project lies entirely within the city of Everett. Let me dwell on access to the current access to the premises for a moment, because I think that appears to be the source of at least some of the confusion regarding Boston's status. The site is currently accessed via Horizon Way, which is a private way. Private way provides access via easement rights.
Horizon Way is where?
Horizon Way is,
This little thing, okay, okay.
It's not within the site plan, in other words.
correct, this is access, it's a private way, it provides access to the site, it is not part of the site.
Can you point it on the other?
This is the proposed access out, this is right here. Our proposed access is over here, and right here.
And Horizon Way
And
is,
Verizon Way is further to the left.
It's right,
No. It's to the left, isn't it?
no, it's right here.
Right there?
so the parcel, the site runs right through Horizon Way?
The access uses a portion of Horizon Way, and then we come down here, we've got the rights over this parcel here that extends out to
Okay, and the vertical property, the vertical sight line there runs through Horizon Way.
Site ends here, Horizon Way comes down here.
But your access is to the east of Horizon.
All in Everett, the proposed access in all.
keep going.
So regarding the current access to the site, again, it's a private way. It provides access via easement rights inherent to all the abutters to the way. A small portion of Horizon Way at the intersection of 99 is located in Boston. So what does this mean for Boston in relation to the wind project? As noted earlier by my colleague, Mr. Weld, it means that Boston fits squarely within the definition of a surrounding community. And I'll repeat, that is a municipality in proximity to the proposed gaming establishment whose transportation infrastructure provides ready access to the proposed gaming establishment.
Can I just gotta clarify this. The site, the gaming establishment site terminates here. And Horizon Way precisely where? Okay, and if it's here, it is, that's, so some of Horizon Way is in Boston, some of Horizon Way is in Everett.
That's correct.
But the portion of it which is in Boston is not included in any way in the gaming establishment premises.
That's correct. These are the gaming establishment premises.
Okay. I'm pretty much clear on that.
Before you put that one away, where is the north-south line from that diagram on this diagram?
This?
Yeah,
It's the same orientation.
but,
Here.
so a part of this diagram, showing the buildings, is to the east of that north-south line.
Yes, this small, this portion right here. We were in discussions with the abutter regarding that.
Okay, but that's all in Everett
It
anyway.
may or may not ultimately be
Right.
included in the property,
Right.
in the project, but it's all in everything.
Yeah, okay,
Not really.
all right, go ahead. Thank you.
This plan shows the project site, the site of the gaming establishment premises, and parcel C, which was referred to in the last discussion. And was also, moved to in, Mr. Wells' remarks. Parcel C is a separate, registered parcel of land court land, has been since at least 1942. That land is, as you can see from the pictures, mostly land underwater and a mud flat and a small sliver that extends out to Horizon Way. The land is currently owned by the owner of the red parcel, which is the owner of the 30-acre proposed gaming establishment site,
That's FBT,
FPT.
all right.
And it is under option to a WIN affiliate that is not the proposed applicant. But anticipating that this may be a source of confusion, we will discuss it today. Some important points about this parcel. One, as I mentioned, this is a separate parcel of registered land, has been since at least 1942. Mr. Weld had the plan up before, which showed that land court plan. The option is not held, as I mentioned, by the proposed applicant, and the land, if acquired, will not be part of the gaming establishment premises. No structures or amenities, gaming or non-gaming, are planned for that area.
Will not and never will be?
Will not and never will be.
And is that something to which you're prepared to stipulate enforceably?
Yes.
Okay.
The land is specifically excluded from the option agreement that's held by the proposed applicant. Because the land is owned by the owner and seller of the Everett parcel, it gave WIN the opportunity to control this adjacent site, and we believe it is prudent to do so to protect against conflicting or adverse uses and possibly use for landscaping or to enhance the view from the site. And we think that would be an appropriate topic for the surrounding community discussions. The site is controlled through a separate entity in order to maintain control of the land, but also, and importantly, to ensure that the land is kept separate and distinct from the gaming establishment premises, and to ensure that Everett is the sole host community. There have been some earlier concept plans, renderings, like the ones that were shown in the Boston presentation, that showed that area with landscaping, dotted with landscaping or shaded in green. These were conceptual plans, very preliminary sketches and renderings, and should not be taken for anything more than that. Under no circumstances will this area be part of the Wynn gaming establishment or project premises. The land is not used by or needed for Wynn for the project in any way, not for zoning or other regulatory compliance, and it is not intended for any particular use. Wynn has no current plans for the land. And as I mentioned, we think it would be appropriate to have that landscaped. It would be to Wynn's benefit to have it landscaped. And there could be other uses for that land, but we think that's an appropriate topic for the surrounding community discussions with Boston. One final point on that land, for environmental remediation purposes, Lot C is a part of the defined disposal site, which is a defined term under the Massachusetts contingency plan. But this has no bearing on its status as a separate parcel or relevance to the Wynn project. If Wynn elects to acquire Lot C, it may assume those remediation obligations, but that has yet to be determined. If it does not acquire Lot C, those obligations would remain with the existing owner. To conclude on that, it's not controlled by the proposed license application. It may never be acquired. It is not part of the...
It's not controlled by?
It's not controlled by the applicant. It is controlled by an affiliate, a different affiliate of Wynn. Wynn Mass LLC is the...
So it's technicality, but okay.
Right. It's not part of the gaming establishment premises or the project site, and as I said, under no circumstances will it be included in any application by Wynn as part of the gaming establishment premises. That's all I have. I think these surveys bear out quite clearly that the gaming establishment premises as proposed by Wynn is located entirely within the city of Everett, and I'd be glad to answer any questions you have.
Has Wynn been given has the city been given these plans?
The city has, I think the bottom plan is part of the NF. What the city has been given is the publicly available documentation, the expanded environmental notification form that Wynn
Has
has
the city
filed.
been given these plans?
Not these plans.
Why?
Well, parcel C, I mean, this is a discussion about parcel C and the Boston land, which is not part of the applicant's, it's not Wynn Mass LLC is not proposing to make that part of the gaming establishment
No,
premises.
I'm saying this package, you're saying these are the sine qua non documents that demonstrate that, in your view, Boston is not a host community. That seems to me a pretty reasonable set of documents you would give to the city, and I'm asking if you have given them to
They
the
have
city.
not.
Chairman Crosby.
And why have you not?
I think that everything is publicly available with the exception of this site plan at the bottom. That's sitting, and I think actually, although it's sitting at the bottom of that easel, it's probably the most relevant document because it actually shows the building and the proposed gaming establishment. We are happy to share that information with the city. And notwithstanding the implication of our being a bit obstreperous, I am going to have to confess that several meetings have been had between our advisors and Ms. De La Russo. We have exchanged correspondence, and we're happy to be as open, transparent, and fair as is possible. So we're happy to share the information. We actually even had a public traffic meeting in Charlestown to try to get this moving. So we're hoping that we're not before you on a repeated basis on issues like this. We're happy to take your guidance, but we'd like to put this issue of host versus not host behind us.
Mr. Chairman,
But the chairman's point, just to follow up on that, Ms. Sinatra, is a relevant one. This makes the discussion, these documents make the discussion possible. These are not renderings. These are meets and bounds descriptions. We didn't get council to the last two, which look like they are the actual plot plans for the registered land that divide the parcels into, show that there are 3 parcels, I take it each of which is registered land,
Yeah,
A, B, and C, separately registered.
True, I didn't go into those again because they had already been discussed, but yes, those are.
And this, it seems to me, is a starting point for an informed discussion. It seems to me that open sharing of this kind of information earlier might have gone a long way toward resolving the problem that we're.
To be clear, though, I think the only slide that the city did not have access to was this one that has the building on it.
I've handed copies of the package to council, Mr. Chairman and Judge McHugh, and the package was assembled for today's hearing. So, we beat it out of everybody to get prepared for this hearing. So I think the commission has done both sides of service by bringing us together here.
Okay, on the Horizon Way, I assume that, although it's not very clear, that you can figure out one way or another to make sure that the site plan does not include any of Horizon Way, so you can, even, I can't exactly see it because you don't have Horizon Way on a lot of these plots, but I assume you can figure that out. You've posited an alternative access point, which is this rounded road coming in from Broadway, I guess. That's in Everett, which is good, but who owns that? Was that under your control?
Yes, this is a 2.4 acre parcel of land down here that we control, so the applicant controls this parcel right here. So the access actually would swing down through here.
Right. All right, so that option, so that access road is one that you do control the ability to institute? Will control, yeah, okay.
And Chairman Crosby and members of the commission, access is something that we continue to work on. Traffic is probably our biggest impact, and so we're working assiduously with our traffic advisors and our architects and planners to make sure that we get the access to be as good as possible. And so the geometry of that access continues to be a point of discussion. As someone raised earlier, of course, our application is due at the end of the year, and we continue to work and refine the traffic analysis and the geometry of the access. One of the things that we keep top of mind, however, is that will be in Everett.
There was a question, or something, the attorneys for the city said something about the municipal harbor plan, and Commissioner McHugh suggested that was in effect a subset of the site plan.
Remember that the municipal harbor plan is a plan of the city of Everett. It is not anything that we control, although we've been in discussions with the city of Everett because it will affect our project. It is not a WIN document. It is not a WIN product.
Boston does have the municipal harbor plan is a process driven by the city. Has a lot of people that sit
By
in
which
the
city?
process.
By which city?
But the city of Everett.
By Everett.
Okay.
And the city of Boston has a representative that sits on that committee and is involved in that process.
Okay.
It was our assumption that they would be reporting back to the city what was going on, seeing that they were a city appointee. So, but that's a process that is not finished yet as the traffic. The traffic is not complete yet. There's ongoing studies through the environmental process. They've asked us to look at 20 more intersections. So it isn't like we have a set of complete documents that we're going to then turn over to someone. These are all work in process. They'll be completed by the time we get our application. Certainly be willing to share them with them. I had 2 meetings and phone calls with the Boston officials. We actually hand carried in the environmental impact report so they could have it. We didn't wait to mail it to them. And we suggested we should meet on traffic issues. And then this issue of post command reared its head, and quite frankly, everybody went into their foxholes. But there were meetings and ongoing discussions and shared information until that specific issue reared its head.
Okay. Well, our purpose, anything, Ombudsman Ziemba, or do you have any?
I just had a specific question. When it comes to the access road, you mentioned that the access road you have control of that site, or Sim will have control of that site?
Right, so it'll either, as Ms. Sinatra pointed out, that the geometry is, is not yet exact perhaps because it may move up or down. And we'll either we'll use a portion of Horizon Way, which we have the right to use as an abutter, or we'll use land that will be acquired.
In your conversations with, for the acquisition of that additional land?
That's correct.
But if that didn't happen, you would use, what's it called?
Horizon Way.
Horizon Way.
It would just shift the access to further down a little bit.
It would shift it to Horizon Way.
A portion of it, but we have rights to use Horizon Way as a private
Oh,
way.
I understand that. But if Horizon Way were the access point to the property, to the site, I guess we're saying, to the gaming establishment site, does that alter in any way this conversation about
No, the
host community or otherwise?
No, Mr. Chairman, it would mean all the more that Boston has claimed to surrounding community status, because the definition of surrounding community means a community in proximity whose transportation infrastructure provides ready access to the premises. So I think it hits it on that nail on the head.
Right, okay. Anything else? All right, well, our objectives here was to try to facilitate a conversation, and it's very easy to understand, you know, what went off the tracks. Mr. Weld, you've articulated, I think, the right approach. I don't think everybody's been going by the right approach. We don't really need to have this meeting, but it looks to me like the facts are pretty clear, and I would hope that everybody could sit down around the table and come to a conclusion, and and quickly, if that can't happen, and by quickly I mean like within hours, days, the time really is short. If Boston were a host community, there would be a host of problems. I'm sorry, yes, if Boston were a host community. If it isn't, and its surrounding community, it is nevertheless going to be a complicated process. So time is really of the essence, never mind the confusion problem. So I would like to suggest, if the commissioner isn't okay with it, that we urge you, you know, we've all been there, we understand that things happen, but this is time to get this one solved. I would like to urge you to get together and fix it before the week is out. I'd like to ask Ombudsman Ziemba to work with you and let us know, you know, on a daily basis, you know, is this going to happen, or do we need to do this? If we do, we will immediately act to do it, but we shouldn't have to. And if you can advise us that this is going to get done before the week is out, then I think all to the good, and we're off to the races, so to speak. Is that acceptable to you folks?
I would just like to sharpen that a little bit, and perhaps the sharpening is unnecessary. But we now have a plot plan. We now have meets and bounds. We now have a pledge that on parcel C there will be no construction. So it seems to me that in going forward with Mr. Ziemba's good offices, the focus can be on, if all of this is so, what are the precise questions about surrounding community, host community that are left?
If any. Right.
That it seems to me not only would facilitate the discussion, but also would sharpen the issues in the event that we are called upon to solve. The other thing that I would like to know, if a resolution isn't possible by, say, the end of the week on this issue, whether either side has an objection to us resolving this by an adjudicatory process in which we create a record that actually incorporates a lot of what we've heard today and makes a legal judgment based on the law and our exercise of discretion, and puts an end to it. And if there is an objection to us doing that, what is the basis for the objection? So it seems to me that those three ingredients of that discussion would be helpful both to the commission and I hope to the parties.
Sounds just right to us, Your Honor.
And those objections, if any, would be to us by the end of the week also, if it turns out that the thing isn't resolved by the end of the week.
Right.
Right.
Very good.
Counsel for the city, are you all okay with this way to proceed?
We are. Thank you for the opportunity.
All right. Thank you, everybody. I appreciate everybody's
Very
coming in.
helpful, very helpful.
Yeah,
Thank
very
you.
interesting. I'm going to suggest that we take about a 10-minute break, and we will reconvene at 10 past 11. It's now 11:15. We will reconvene Mass Gaming Commission Public Meeting Number 76. And we will return to Ombudsman Ziemba and General Counsel Blue.
Thank you, Mr. Chairman, members of the commission. The second item that we're here to discuss today is a transaction involving the Plain Ridge Racing Facility and a citizen's notice that relates to an election that is planned for the town of Plainville for September 10th. We have some documents that are included in your packets As of last night, we received some additional documents from the town of Plainville. I've also given you a copy of those. We'll include those as part of the commissioners' packets that are placed online. So there are a number of different documents that are included here. I will ask the Penn representatives to give you a little bit more detail about those documents, but let me just give you a general overview of some items that we can discuss today. So one of the primary documents, and it's noticed on the agenda, is a citizens notification. Similar to other communities, the town of Plainville, when it first adopted the host community agreement, voted to take advantage of the exception in our regulations, which would allow the town to move forward with a referendum in advance of a determination of suitability by an applicant. The election for the application is scheduled for September 10th, and the notice that is included in your packets relates to the September 10th election. Now, obviously, the commission had an adjudicatory proceeding last month, at the end of July, that related to this project, where the commission determined that the Our Way Realty applicant was not qualified to move forward to for the stage 2 of our licensing process. So the citizens notification form, it is, albeit very much like most of the forms that the commission has approved to date, but it does include a number of different information points that relate specifically to the aspects of this project which are unique, notably that we had one applicant that was disqualified for the purposes of our IEB reviews. If it's okay with the commission, I would recommend that we discuss the actual aspects of the citizens notification form until after we learn more about the transaction that occurred as of yesterday. A number of those documents are included in your packet, redacted documents that have been provided by the Penn National team. We have not done our own review of whether or not those redactions are in keeping with our standards, whether or not they're overly redacted, or I guess under-redacted, but we are relying upon the applicant that they probably didn't under-redact their own documents.
So we're not going to release, I guess we will release the presently redacted version, but making it plain to the applicant and the press and the public that there may be unredactions after we've had a chance to look at it. Okay.
That's right.
Yep, that's correct.
So there are a couple of key documents that are part of the commissioner's packet. One is an option agreement between Penn National and Our Way Realty regarding the option to purchase some of the assets of the existing Plain Ridge Racing facility. One is a document that relates to the assignment and assumption of the host community agreement, whereby the Penn National team would assume the responsibility for the host community agreement that had been executed between the town of Plainville and the Our Way Realty team. I report that as of last night, the town of Plainville voted pursuant to a provision included in their host community agreement to allow for the assignment of the host community agreement to the Penn National application.
What was the vote?
Was that the town or
That was-
the Board of Selectmen?
That was the Board of Selectmen.
Okay.
And
Yep,
what was
and
the
it was
vote?
a unanimous vote.
Unanimous vote, okay.
So with that, I'd like to introduce Mr. Steve Snyder. He's the Senior Vice President for Corporate Development for Penn National. He'll introduce the rest of his team. We're also joined here by representatives from the town of Plainville and representatives from Our Way Realty to the extent that the commission has any further questions. But I think that there is a general realization that we can take a look at two different sets of documents, which are the transaction-related documents, and then the citizens notice is a separate and distinct item. The Penn National team has asked the commission to take a look at the transfer of the host community agreement from Our Way to Penn National, and to consider that. They made a request that the commission consider that, and we also have a separate letter of request that the commission approve of the citizens notification form. So with that, I'll ask Mr. Snyder to provide us a briefing.
Thank you, Mr. Ziemba. Good morning, Chairman Crosby and members of the commission. I'm Steve Snyder from Penn National Gaming. To my right is Jay Snowden, who's our Senior Vice President of Operations. To his right is Eric Shippers, our Senior Vice President of Government Affairs. Going down the line is Frank Donahue, who's our Vice President of Compliance and Regulatory Matters. He's worked extensively with your staff on our Phase 1 application. And next to him is Walt Sullivan from Preddy Flaherty, our legal representative, and behind me is Alex Stolier, our Vice President of Development. We very much appreciate the opportunity to be here before you. We apologize, quite frankly, for the short notice. This has been truly a work in progress, and in terms of transparency, I don't think anyone has been quite as timely with an issue as we are with this one. As Mr. Ziemba mentioned, we just yesterday entered into an option agreement. That option entitles us to purchase all of the real property and assets, personal and real property, of the current operation at Plain Ridge Raceway. We also just last evening, as was mentioned, did receive the approval of the selectmen of the town of Plainville for an assignment of the obligations and the rights under the host community agreement for the operation of a gaming facility at the Plain Ridge Raceway. So we are here as quickly as we could. We've been in negotiations with the principals on this option agreement over the course of the last really 7 calendar days, and only as of yesterday afternoon entered into the definitive option agreement. As was mentioned in his comments, Mr. Ziemba, we have provided to the commission that option agreement in redacted form, and will ask as part of our suitability review, which we hope to have a hearing in the near future, for the approval of that option agreement. For purposes of today's discussions, our specific request relates to the approval of the assignment of the host community agreement from our way to the Massachusetts subsidiary of Penn National Gaming, as well as an approval of the notice to the voters of Plainville relating to the special election, which has been scheduled and is currently anticipated to be held next Tuesday, September 10th. By way of background, we have filed our Phase 1 suitability application back in January. I know your consultants have done all of their work in respect of our background investigations, and we hope to be before you in a matter of weeks for the final determination of suitability, since that is expected to occur after the election in the community of Plainville on September 10th. We are following through on in the same fashion that the previous principals of Plain Ridge had undertaken, which was to make the approval of the election and acknowledge that the suitability would be a forthcoming matter, something that would come after the fact. We, as a company, have been heavily involved in pari-mutuel racing. We started, in fact, we draw our name from our legacy race course, Penn National Racetrack in Pennsylvania. As of today, we operate through either wholly owned subsidiaries or joint ventures 11 pari-mutuel racing, pari-mutuel wagering and racing facilities throughout the United States. The closest would be our harness racetrack up in Bangor, Maine. And of those facilities, 4 of them are standardbred racetracks, harness racetracks. It is our intent through the option agreement that we will close on the acquisition of all of the assets of Plainville. We will proceed with the submission of an application by the October 4th deadline, the Phase 2 application relating to our previously submitted suitability finding, and this new piece of real estate, which we, as I mentioned, have entered into an option as of yesterday. We would anticipate closing on that option and actually becoming the fee owner. We are currently the beneficial owner through that option agreement, if and when we are found or selected by this process to be the Category 2 licensee. In the meantime, it is our intent to continue to operate harness racing at Plainfield Racecourse. We will be applying and have sought the ability to operate the facility for 2014 from the existing property owners prior to exercising the option to acquire the land, so that we can actually operate harness racing, apply for a license apply for continuity of that enterprise in the form of both live racing as well as simulcast wagering for calendar 2014, so that there will be no disruption to the ongoing operations of that enterprise in 2014. We appreciate the chance to be here this morning. We've got a full team that is prepared to answer any and all questions that you might have, but really the only action that we seek as of today relates to the host community agreement and the vote currently scheduled for September 10th. So with that, I'll answer any questions. If there are any areas of either the notice or of the assignment of that host community agreement that we can address, I'd welcome the opportunity. As Mr. Ziemba mentioned, the town manager is here as well if there are any questions of the town.
Anybody want to start? Well, if you said we're here to talk about the notice, which we clearly are, and we're here to talk about the host community agreement and the issue being the assignment thereof. But it seems to me that raises a third question, which is, if there is this assignment, which I'm not a real lawyer, but it looks to me like by contract law, that's perfectly legitimate transaction, what happens to the applicant? And the requirement that there have been a host community agreement signed by the community and the applicant prior to the application ever becoming selected, et cetera. So we've had several communications from folks in Plainville who are opponents who are saying this isn't the applicant anymore. Yes, you can take the HCA, but you don't qualify as an applicant. So I think there's a third issue which arises from the assignment. And I'm interested in, well, first of all, disagree with me if anybody disagrees with me, but up here, but I'd like to know how you fit within, how you fit this assigned relationship or this new relationship into the definition of an applicant.
Well, we are a phase 1 applicant. That application was filed back in January. We continue to be a phase 1 applicant. We've not withdrawn or not been found unsuitable. And we are coming to you now with an option on a piece of land that was the beneficiary of a host community agreement through a previous applicant who has subsequently withdrawn that application, and seeking that we continue to be the beneficiary of that host community agreement as it relates to that site. And it is the site and it's the operations of racing at that site that are referenced in the ballot question.
But Chairman Crosby's question, I think, and of course he can speak for himself better than I can, focuses on specifically on section 1513 of the statute, which repeatedly talks about a request. The whole host community voting process is triggered by a request for an election that occurs after the signing of an agreement between the host community and the applicant. And then that refrain, host community and applicant, is repeated throughout section 1513 and is the governing matrix for the host community election. And the question is how, you're the assignee of the applicant that signed the host community agreement, but you're not the applicant.
No, to your point, Commissioner McGee, we are clearly the successor under the host community agreement of that previous applicant. There's no question.
Right. And so how does your status as a successor comport with the requirements of section 1513, if there's to be an election?
I'll ask if you could pass the mic down to Walt, or switch seats.
Sorry, they don't.
Whenever I start talking about legal things, I get myself into trouble, so.
So do I.
So do I.
Section 1513 does talk about the applicant, and that the applicant enters into host community agreement and so forth to the election, to filing. The original intent of the legislation really wasn't breaking it up into two phases. So what we're looking at, we are the applicant for purposes of Phase 1. There's no question Penn filed Phase 1 application.
You are an applicant,
Applicant.
not the applicant.
Applicant, excuse me. Thank
Right.
you, Commissioner,
Okay.
Mr. Chairman. In that the rights of that host community agreement by contract has been assigned to Penn. The commission in forming Phase 2 had great discussions about the issue of what their involvement should be in the host community agreement itself. In the end result, I believe, was the commission made a determination that they don't get involved in the contract. However, they do get involved in the Phase 2 application is when it's submitted. The host community agreement as entered into between the town.
Just for the record, that's not what we've said. What we've said is, we don't get involved in what the legislature saw as local, a local control issue unless either A, something in that process is impeding or the integrity of the overall process, or impeding the, our process itself.
In the host community agreement, there is a section that allows for assignment upon the approval of the town. And that assignment was exercised between both our way and Penn subsidiary of Massachusetts and consented to. So we have before us a host community agreement that is now between Plainville and the subsidiary of Penn. And that's what we're moving forward with. I mean, you're looking at a system today that, as to Cordish, they've been in 3 towns, trying to accomplish the best for the Commonwealth and moving forward to generate the most revenues. Every operator is trying to find a location. We are a Phase 1 applicant. We've been looking for a place to develop. We found a great location in Plain Ridge and Plainville that truly meets what Penn's history is. The town is on board with this. The town's on board with this. Our Ways assigned its rights. We have an option in place. This not only benefits a Phase 1 applicant who is trying to find a home for Phase 2, it benefits the town who worked diligently to accomplish an incredible host community agreement and did everything it can to protect its citizens. It protects the harness men to ensure that the track stays open.
Excuse me, but just, I appreciate that, and I don't want to be rude to cut you off,
No,
but I appreciate those points. But let me just tee up more specifically what I'm concerned with as a legitimate issue. Section 15 says, no applicant shall be eligible to receive a gaming license unless the applicant meets the following criteria and clearly states as part of an application that the applicant shall. In this context, I think we would agree that the word applicant here refers to, you hope, Penn National.
Yes.
Then in section 13, it says, one of those criteria is that the applicant, Penn National, shall have received a certified and binding vote on a ballot question at an election in the host community in favor of such a license, provided, however, that a request for an election shall take place after the signing of an agreement between the host community and the applicant. If the applicant's Penn National, that didn't happen. What's the legal rationale for you all complying with that criteria? How do you get Penn National to be the applicant that meets this criteria?
On the host community or the election? Or both? On the host community agreement or the election, or both?
Both.
On the host community
Well, either.
agreement by contract, by assignment. The applicant, for purposes of the process now, we've submitted Phase 1. At Phase 2 application, we're required to submit a number of things, plus a host community agreement that has been executed, and a binding vote of the citizens approving the election, approving that the facility be located at 301 Washington Street, and and that they approve the summary of the host community agreement that has been entered into between the Board of Selectmen and now in the shoes of our way, Penn.
I think, Chairman Crosby, to your point, I mean, we do not view yesterday's approval of the assignment of the host community agreement as the, for lack of a better term, the effective date of the host community agreement.
No, yeah, but the issue for me that comes out of this is whether the identity of the applicant is a part of the information.
that the legislation intended to be before the voters for 60 days before the election occurred. It talks about the election, the triggering event is the signing of an agreement between the host community and the applicant. And then you have this minimum of 60-day waiting period. Is that to familiarize the citizens, or permit the citizens to familiarize themselves with the terms of the agreement solely, or with the terms of the agreement including the identity of the parties to the agreement? In that regard, it seems to me that as a matter of contract law, the assignment is valid, and you stand in the shoes of Plainridge. But this is a procedural device superimposed on contract law, designed to give the public a say and an understanding of what's up. I suppose there's a more precise way to express that. So the question is the identity of the signatories a part of what the legislator intended the citizenry to have 60 days to think about?
Commissioner, let me just add something on that point, on sort of the public awareness point.
Right.
So the ballot question itself talks about Plainridge Racetrack, doesn't talk about the operator. It's very clear as it relates to the racetrack. The host community agreement has not changed. What has been assigned to us are the same terms that were agreed upon, and a great deal of education efforts have already been undertaken in the community on what those benefits are to the community and what the benefits of slot machines at Plainridge Racecourse will mean to that operation. And so then it comes to pass, what about Penn National and the awareness of this new operator that would be coming in within 7 days of the election? We had an opportunity to address the public last night during that meeting Mr. Snyder referred to. We have a public forum tomorrow night where we'll be taking questions from the public about Penn's background and allowing them to ask all types of questions about what our plans are, which are very similar to the plans that have already been laid out to the community. We will also be continuing to meet with the neighbors. It's a very small community, and so we have a very robust campaign plan, including print advertisements, phone calls to residents, community forums, to make sure that by the time they go out on September 10th, having already knowledge of the racetrack's benefits, the saving of the jobs that Mr. Sullivan referred to, knowledge of the host community agreement, now they'll have that added layer of knowledge with who Penn National is and our background. So we think they'll be in a position to make an informed decision at that point.
And to Mr. Schipper's point, as you read the language of the ballot question, a yes vote would allow the owner of Plainridge Racecourse to apply to the Massachusetts Gaming Commission for a license to operate a gaming facility in accordance with a host community agreement executed between the town and the racecourse's owner. There's no temporal concept there. It's not the racecourse's owner as of today or as of 60 days ago as you read it.
But that raises a separate question, Mr. Snyder, because under the terms of the option agreement, as I understand it, Penn National is not going to be the owner necessarily until 60 days after the award is made.
No, the option agreement is an executory contract. We've got the full rights of ownership of the property as of the execution date of the option. In fact, we're recording the option and filing a recording instrument as it relates to the title on the land as a result of that option. We are the full beneficiary of that land, correct. We haven't taken the title at this point in time, but all decisions with respect to that property are in our control, and we've got the full benefit of an ownership interest.
Well, unfortunately, you may well be right. We haven't had a chance to really look at the option agreement, which we got
Understand.
last night. So the essence of your suggestion is that although the technical requirements of Section 1513 may not have been met, the substance of voter information and awareness the ideal, the underlying premise of the legislation has or will be met. That's basically it, right?
Well, I can't argue to the legal aspects of technical. I'm talking about the public awareness aspect of your question. Will the public, based on the legislative intent, have full knowledge of what they're voting on? And I would argue that not only has there been such a lead up to the issue of what goes into the host community agreement and how that's been communicated, both through a very strong citizens advisory board and public forums that they've had, in addition to other outreach efforts in terms of saving the jobs in the open space. And so the arguments have been made, and they've been a good corporate citizen, the racetrack there for 15 years. The only changing dynamic, HCA stays the same, benefit to the racetrack stays the same. The only changing dynamic is who is Penn National. And what I submit to you is that we will have ample time in a very small community to make the community aware of Penn National and its track record, pardon the pun, by September 10th.
And Mr. Chairman, the representatives from the town are here and they can, of course, walk you through the notice that they would plan to send out with your approval.
And with your permission, Mr. Chairman, members of the commission, I'm Jonathan Silverstein. I'm counsel for the town of Plainville. If I might just take a few moments to answer some of the questions that the commission members have asked. From the town's perspective, I hear an overriding concern regarding perhaps the potential for voter confusion and what the role of the voter is, and whether the voter has in some way been inadequately informed or perhaps inadvertently misled based on a host community agreement being entered into with one applicant, subsequently with that applicant to transfer its rights and obligations under the host community agreement to another applicant. I guess I would turn that on its head, and I would note that the real danger of voter will being undermined here is if the voters don't have an opportunity to vote on this project, which is of great importance to the town, under a host community agreement that will not be changed one iota. And I think that would be respectfully an absurd result, given that post-licensing, there's no doubt that the assets and the license could be transferred with the permission of the commission, with the permission of the town, both under the statute and the regulations and under the host community agreement itself. So the notion that that could not happen prior to vote or prior to licensure, I don't think would serve any public purpose under the gaming legislation. Really, I think the legislation draws a line, and your regulations draw a line between what the chief executive body of a municipality does, what the voters of a municipality do, and what the commission does. The chief executive body decides, do we want to negotiate with this applicant? And if so, what are the terms that we'll agree to be? In that case, that's the Board of Selectmen when it comes to a town such as the town of Plainville. The town decided, yes, we want to negotiate with the owners, the then owners of Plain Ridge Racecourse, Our Way Realty Trust. And so you could argue that to have another applicant come in now could somehow undermine what that chief executive body thought it was undertaking when it negotiated an agreement with Our Way Realty Trust. And that would be a legitimate concern, but for the fact that last night unanimously the Board of Selectmen, pursuant to a specific provision in the host community agreement, agreed to approve of the transfer. And there's a consent to transfer agreement that was negotiated last night by the Board of Selectmen and the representatives both of Penn and Our Way. Then you look at what the intent of the legislation is with respect to the voters. And I think it's clear, you look at the form of the ballot that's prescribed by the statute, it requires a summary of the host community agreement, the substantive principal terms, and it requires, in the language of the question itself, that the location of the proposed gaming facility be identified. There's no reference in the gaming statute requiring the particular applicant or ownership structure of the applicant to be referenced either in the ballot question or in the summary. And I think it clear that questions about whether to negotiate with an applicant, a particular applicant, are left to the chief executive body of the town. questions of whether to approve the suitability of the applicant are left to the commission, and questions of whether the project itself is more advantageous to the town pursuant to the host community agreement are left to the voters. And that's what I think if you, I'm not a pollster, I'm not in a position to represent anything to the commission that there's been a poll taken, but I am quite certain that if you polled the people of Plainville, they would say that they want to have the opportunity to vote on this very important project for the town. I think that neither your regulations nor the statute, quite frankly, contemplated this eventuality, that you would have a phase 1 applicant that was deemed unsuitable and that another properly applied phase 1 applicant would attempt to step into their shoes. And so I think where the legislation and the regulations are silent on those issues, they should be interpreted to effectuate the purposes of the legislation. And the purposes of the legislation, as oft stated by this commission, are to further competition, and certainly that purpose will be effectuated, and to thus maximize the benefits both to the host community and the region and to the Commonwealth as a whole. I think all of those purposes and the purpose of letting the voters vote on an agreement that's been very well publicized, very well discussed, will continue to be. I don't think there's any risk of voter confusion with respect to the terms of the agreement. As has been previously referenced, it's a small town. Everyone in town is going to know that there's been an assignment to a new applicant. And if this could, as I think everyone will agree, if this could easily happen post-licensure and post-vote, where the legislation I would submit is silent on this unanticipated eventuality, I would respectfully submit on behalf of the town of Plainville that the commission allow that vote to take place and approve the notice so that the people of Plainville can vote on this project.
Yeah, I think I recall a number of discussions in the past amongst ourselves relative to asking the applicants to designate a site. This was during the phase 1 suitability process. And we never said a minimum of X days or you have to designate your site, et cetera, because there was a lot of discussion around that not being paramount to the purpose of the phase 1 process. But to the question of that Commissioner McHugh poses relative to the identity of the applicant as per Section 13, it occurs to me that this is not a question for our attendees here. This is clearly a question for us, unless somebody corrects me about that assumption. Perhaps the most relevant factor relative to the identity is one of suitability. If it is one thing to hear about a particular company, but it's really the suitability that will inform the public, and first this commission and then the public, as to whether the applicant is suitable. And we contemplated just what is happening before us, which is that an exception to a reg that suitability may not be done prior to the vote taking place. And I submit to all of you that this is within the confines of our regulations. It becomes a matter of that assignment, if we are satisfied with that assignment, I suppose, and that should be the question to discuss.
Well, I don't quite agree with that. I agree with a lot of that, not all of it. I think the assignment, probably is fine. There seems not to be any issue with the assignment. There are two, and it's been vaguely alluded to, there are two strong public policy arguments, in my view, in favor of us going along with this proposition. One is the local control issue, and we have said that as much to the maximum extent possible what the legislature wanted is to have these issues decided at the local level. We've respected that. it's entirely appropriate. And, you know, a 5-0 vote by the Board of Selectmen is a pretty strong vote, and people who are opposed to this have a way to respond by voting those selectmen out if they don't want them. So there's a strong argument in favor of that. A. B, as some of you have said, we have all along been trying to encourage competition. It's good for the Commonwealth in the long run if there's competition. So I think those are clear, and I find those compelling. And I think the assumption of the HCA is not a problem as a matter of contract law or our regs. But it does raise this technical problem, which is that the literal words of our statute and regs don't quite work here. We have an email from a Marianne Grenier, and she writes, as I read the Gaming Act, it clearly states the applicant must sign the host community agreement 60 days prior to the holding of a voting referendum. If an applicant does not sign the HCA 60 days prior to the referendum, the application is incomplete regardless of the vote. There is no subjective determination needed as to whether the applicant signed the agreement 60 days before the vote. Either it happened or it did not. And it's similar to the point that I was reading. The word applicant in the law and in our regs applies to two different entities at different stages of the process, and there is nothing that says anywhere that that's okay. The lawyer for the community, I think, makes an articulate case that it's a mere technicality, that this was not anticipated. There are arguments in favor of it, but I do think that there is a fair reading of the technical language that makes this inapplicable, and it's not one that and you know, this letter goes on to say that we'll contemplate legal action on this point, which is people's right. So I think we have to take this pretty seriously, and I'm going to suggest, unless people want to talk about it further now, I would like to hear if there is anybody out there who believes that this technical issue that we're talking about is really substantive and should be a bar. I would like to hear that argument. We're only hearing from people who are in favor of this going forward. I don't know if there's a meaningful number of people or entities who have another view, but I think this is important enough that if we render a judgment, we ought to hear the other side. So I'm going to suggest that we don't adjourn this meeting when we get done to it, that we temporarily adjourn it, that we reconvene on Friday. We will presumptively have an adjudicatory process, a hearing at that point, where we will once again consider these issues. That will strengthen whatever decision we come up with. We invite anybody who has an opposing view to tell us about that opposing view, and if it seems appropriate, we'll invite them to have an opportunity to speak at that hearing. And we would then deliberate on that and make a decision, hopefully, before the day is out on Friday. Does that?
I would agree that that's a sound process, though I would not commit ourselves to an adjudicatory hearing at this point.
I said presumptively adjudicatory.
Okay. I just wanted to emphasize that,
Okay.
Mr. Chairman. I just want.
Okay.
But I think that hearing the other side, I came into this thinking more strongly than I do now, quite frankly, than the applicant piece was a bar, and for a variety of reasons I'll be happy to articulate unless something else comes up. I'm shifting in my views there, but I do think it's important to hear others, the other side, if the other side wishes to be heard. So.
I agree with that. I do have one quick question I want to address the attorney. You mentioned a provision in your host community agreement, which right now we don't have a copy of, but I'd appreciate seeing the provision you reference in the host community agreement that is relative to a transfer.
Certainly. It's paragraph 8 of the host community agreement. I only have a marked up unexecuted copy with me. The town administrator has an executed copy that we can provide to the commission.
You say paragraph 8, you mean section 8?
I'm sorry, section 8. Section 8 on page 7.
Oh, no, I'm sorry.
Commissioner, I believe I have extra copies of the host community agreement.
I have it here, but section 8 is permit fees.
I'm sorry, that's section 8 under section 3, I believe. It's subsection 8 that you're looking at on page 7 of the agreement.
You see it, Bruce? You got it. Yeah. Commissioner Stebbins, do you have further?
No, thank you. I just wanted to see the portion that the council referenced.
Well,
Oh, I'm sorry.
please go ahead.
Of course, if it's the commission's will, we'll all come back on Friday. I guess the one point I do want to note is that the election is Tuesday.
Yep.
And so I would ask at a minimum that the voter notice be approved so that we can get that out sufficiently in advance of the election. And I guess the only other point I would note, again, of course, we'll come back if that's what the commission deems appropriate. Ms. Grenier, who wrote that email, is, as I understand it, can confirm the leader of the opposition in town to the project. They have spoken, and of course the commission has heard their points. I don't know what else would likely be articulated, but of course that's a matter for the commission to decide.
But opponents sometimes have something valuable to say.
Strange as it may seem.
And I think they have, but, and I understand she's here today.
Yep. But she makes a point of saying she's not a lawyer, and they're going to talk to lawyers. And, you know, I share Mr. McHugh's. I came in here thinking this is really complicated. I mean, and, you know, this is so bizarre. Is this whole transaction, doesn't make any sense. And I think the more I talk about it, the more I'm leaning towards the fact that net, when you try to look at all the overall net policy considerations, you know, I lean towards going forward on this. But whatever decision we make, whether we go that way or not, we want this to be bulletproof, for good or ill, for, you know, whichever way it is. I've leaned one way one time, and I might lean another way another time. And I'm open to trying to make a decision today if others think we should. But I feel like there's enough substance to the issue, albeit possibly merely a technicality, that it would be worth us taking 2 more days to figure this out.
Excuse me, Mr. Chairman, if I may.
This is all part of our keep lawyers employed strategy, which is a major part of our business in life.
You know, as Mr. Silverstein pointed out, we're in a very unique situation because of an applicant being disqualified. Under your own regulations in 131, you anticipate this happen if a licensee is revoked. If a licensee is revoked, you have the ability to replace them with a new licensee. And that new licensee assumes and is assigned the obligations under the host community agreement, and there's no requirement for another vote. So the voters are left with the commission picking someone new coming in. This is within the town has made a decision as to who they want to do business with. The host community agreement, along with the vote to the people, is really the location and what the host community agreement says.
Right, but I think that's missing the point. You know, we agree with that. We understand that. We agree with that. But the statute and the regs set out certain conditions under which a license may be granted. And in a literal reading of this, as I read it, certain of those conditions may not be met. Whether that matters or not in the big picture is a debatable point. But in a literal reading, it seems to me there's a problem there.
And I think in the process in 131, they're required to fill out the Phase 2 application again. Arguably, that would mean that they were required to get another host community agreement and another vote, but that's not what the commission laid out in its regulation.
I believe they're required to go through the phase 1 suitability.
They've already, yes, they have to, but for purposes of location, that they must be located in the specific location that the prior licensee was located at, and they must adopt and fully be assigned the host community agreement and any other surrounding community, et cetera. And I think you raised, although we're not this particular situation, anticipate potentially down the road a licensee either walking away or being revoked, and the commission doesn't want the place sitting there. They're going to allow someone to step into their shoes.
You know, for everybody, including you, this arose with a great deal of speed. The issue is an important one, and I share the chairman's concern that we think it through carefully, though I'm leaning in the same direction as to the outcome for a variety of reasons. It seems to me that we have two issues. One is the text of the notice to the town and the fact that the election is about on us. And second, whether we approve the transfer and the underlying transfer under these circumstances. It seems to me that we could approve the language with the addition of a sentence to be worked out with Ombudsman Ziemba, indicating that in addition to there not being a commission determination of qualification, the commission, as of the date of the letter, hasn't approved or disapproved of the transfer.
But that it will make that decision prior to the election.
But it will make that decision on Friday.
Right.
And then commit ourselves to making the decision on Friday. And let that letter go out, so the townspeople who read it will know that before the vote, they'll have a decision on that. And let that go out, and then come back and see if there is anything we haven't thought about in terms of the approval of the underlying assignment, and then make a decision on Friday.
Yeah, I agree. If there's a real strong argument, I'd much rather know it now than after the election and after we're further down the process. So I agree with that. Are you guys?
I would agree with that. And I've looked at the notice. It appears fine with your suggestions. It appears even more appropriate. Yeah. And if we can make a decision by Friday, it would be really of the time of the essence, really.
Right. Yeah, I think we'd be able to make a decision.
Yeah. Right. Any other comments? I mean, I think we are pretty much ready to make a motion on this. But if you have anything else to say, please do.
Mr. Chair, I suppose the only other point I'll make that was just made to me is, of course, if the commission remains concerned about this issue, this won't be the last opportunity for the commission to address it. You could always address it in the context of the phase 2 hearing process. So perhaps that might be another resolution for the commission to consider.
Yes, but if we address it there, we will have consumed an enormous amount of commission energy, town energy, and perhaps other unexpected forces in the interim. So it's better to try to get it right now, as right as we can get it, even though I recognize that it would cause some inconvenience and some concern and some need for Tums or something.
Yeah, I mean, one of the challenges we have heard that one of the strongest tactics of the opposition has been to sow seeds of doubt in the community and try to give people a reason to stay home on election day because of this uncertainty. And it seems like to some extent there is a conclusion in search of an argument that the opposition needs to go and seek an attorney and come back. And in the meantime, we'll have days of advantage on us to continue to sow this uncertainty. And I guess my argument would be, if you allow the election to go forward, certainly both sides will have ample opportunity for them to make their arguments and for us to make our arguments. And ultimately, this issue will be decided at the ballot box.
And I guess I'm sorry to interrupt, but the only other point I would make is there is no question that the election will go forward. The election, under state election law, the election has to go forward. So the question really is whether the commission is going to approve or accept of the transfer. That I don't think that is going to affect, I know that cannot affect whether or not the election goes forward.
Right.
We're required to, at this
Right.
point, absentee ballots have been pulled
Right.
and returned.
And if I may add, members of the commission, we still have many other steps, and that this has already been noticed that the applicant, suitability finding on the part of the applicant remains to be determined. And as was pointed out earlier, the phase 2 process has not even commenced at this point in time.
Right.
Are we all right to go with?
Yep, yeah, I think.
I think we need a motion, but I think we see, I know there's somebody else who wants to speak, but I think we are going to decide to have a further conversation. It looks like we have a consensus, which we will put into a vote in a minute. So I'm not going to invite other people to speak. That opportunity is going to come. Looks to me like it's going to come on Friday. Do you want to frame a motion?
I move that the commission approve the Town of Plainville's notice to voters with respect to the September 10 election as presented by the town to the commission, with the addition of a sentence to be worked out with staff for the commission that informs the voters that as of the date the letter is sent, the commission has not yet approved the transfer of the obligations and rights in the host community agreement from our way to Penn National, but that it will make a decision on that transfer on Friday, whatever the date is.
September
Period.
6th.
Second?
Second, and just a note, not necessarily an amendment, but in the notice, and I would implore obviously our own team to do this, we identify the town's website and the Mass Gaming Commission's website. I would implore both our team and the team in Plainville that's your homepage. Let's make sure that information or a link to the appropriate agreement is front and center so we don't have to have voters scurrying through 50 menu items trying to find a copy of this. Time is of the essence.
Any further discussion on the motion? All in favor, say aye.
Aye.
Opposed? The ayes have it unanimously. We will be back to you with details. I apologize for the inconvenience, sort of, but it's what you guys want us to do. You're asking for this issue. And we'll be back to you. It'll be Friday afternoon. We'll send details to everybody as soon as we possibly can.
Thank you.
Thank you. Thank you.
All
Thanks
right.
for your time.
I'm going to suggest we adjourn for lunch. How much time do we want? Is a quarter of enough, or
1 hour?
1 o'clock? Quarter of 1.